The arrest and arraignment of former Attorney General of the Federation AGF Abubakar Malami and his son Abdulaziz marks one of Nigeria's most consequential post-office prosecutions, raising sharp legal and political questions about accountability at the highest levels of government. At the heart of the case is the Terrorism Act 2022, particularly Section 26(2), which criminalizes failure to prevent, investigate, or report terrorism financing. Prosecutors argue that Malami's former role as AGF, Nigeria's chief law officer, imposes a higher threshold of responsibility. This distinguishes the case from ordinary terrorism financing prosecutions and reframes it as an alleged breach of constitutional and statutory duty, not merely personal misconduct. The terrorism charges intersect with earlier financial crime allegations. Malami has previously been linked to an EFCC probe involving 8.7 billion in suspected money laundering, including asset tracing that led investigators to search a residence in Birnin Kebbi. Analysts note that authorities are now treating these matters as potentially connected, suggesting a pattern of financial flows rather than isolated incidents. According to court filings, Abubakar Malami and Abdulaziz face charges of terrorism financing, aiding terrorism, and illegal possession of firearms, including a high-caliber Sturm Magnum weapon, under the Firearms Act 2004. Prosecutors further allege that Malami, while AGF failed to act on terrorism financing case files submitted in November 2022, effectively shielding suspects from prosecution. At their arraignment before the Federal High Court in Abuja, both defendants pleaded not guilty. The court denied bail and ordered their remand in DSS custody pending trial, with proceedings adjourned until 20th of February. The case follows a turbulent timeline: Malami's detention at Kuje Correctional Centre, his release in December 2025, and a subsequent DSS rearrest in January 2026, sparking sustained reactions from civil society groups and the Nigerian diaspora, who view the trial as a test of whether counter-terrorism laws apply equally to former power holders. As proceedings unfold, the outcome may set a precedent for prosecuting senior officials under Nigeria's post-2022 counter-terrorism framework.